No, I don't think it's that one. Good afternoon. This is House Judiciary Committee on Wednesday, the 29th of January, 2025. We have only 4 bills today, but the first one we're going to hear is House Bill 229. Delegate Chisholm, if you want to come on up. And who else do you have? You have Shannon Ledbetter. Is that you? Okay, that's fine. And then Bill Castelli. I saw him. All right, that's fine. Matt Hill, are you here? Matt Hill is not here yet, but he's favorable with amendments, so we'll hear from him next. With that, we will go with you for 3 minutes and everybody else for 2. Go right ahead, Delegate.
Thank you, Mr. Chairman. It's good to be back here in Judiciary. I do feel a little uncomfortable without Delegate Aircan being here to yell at me, but we'll work through that. This is a yeah, I'm sure she's heard by now. This is a bill we heard last year. This committee was gracious enough to pass it out for me. It did pass out of the House unanimously, made it over to the Senate. Just like my little friend Bill from the Saturday morning specials, it got killed in committee. So we're back here again. I was smarter this year.
Are you not sick?
I made sure that we had a strong cross-file on the other side. Senator Dawn Gile did cross-file it. Her hearing was earlier this week. Seemed to go very well. Once again, this is a tenant holdover bill, very specific for military members that are on active duty, that get military orders to come back to Maryland. It only applies to primary residents. The military member or their spouse must plan to occupy the property as their primary residence within 30 days. And it only applies if a lease is in a holdover status, meaning they can't kick somebody out before their lease expires, so the leases expire. So in this case, somebody would be sent back here, find out they have somebody in their house and they can't get them out. We did reach out to Judge Morrissey last year, and once again this year, we just asked that hearing be held within 45 days for the military member because of obviously the military orders are a strain on the family, and they want to make sure that we can get their day in court in a timely manner. And the other aspect of the bill, once again, is if the sheriff's office receives notice to send citation over for the eviction, they must do it in what's under law statute now within 10 days. If they cannot meet that 10 days, then you have the right to use a process server. That actually came from the sheriff's office in Anne Arundel County because he indicated to us that they are so overwhelmed with the service or the citations and the warrants that they have to have applied now, that it's very difficult on them, and they had no problem with it. If they couldn't meet the 10 days, then it allows a military member to then employ a private process server to serve the eviction papers. And with that, I'll turn it over to my panel.
Thank you. My name is Shannon Ledbetter, and I live in Anne Arundel County, and I'm here as the spouse of a retired Marine in support of HB 229. During my husband's 20-year career, we moved on an average every 3 years. Moving that often is hard. It's the mental, emotional, physical, financial, and logistical challenges that are a burden. As soon as a military family receives orders, an entire process begins. The spouse updates their resume and undertakes a new job search, the search for childcare in the new location. Insurance must be updated and changed. Utility services are all transferred. Car insurance has to be changed as well. The packing of household goods, all to be coordinated. The dates of your unit checkout have to line up with your move out, which needs to line up with your new move in, which has to line up with your unit check-in. It's a whole process. Your travel, often across country, must be planned. children's school documentation, report cards, testing results, possibly teacher recommendations, all have to be collected from the old school, and proof of residency must be collected for the new school. All goodbyes have to be said. You have to find ways to cope with the loss of friendships, support networks, lifestyles, communities, and spouse careers. Now imagine doing all of this every 3 years. It's a hard lifestyle to live. I cannot calculate the additional stress placed on a military family who endures all of this and then cannot move back into their home because a tenant is holding over. However, I can calculate the financial impacts. Regardless of circumstances, the military member is only reimbursed for 10 days of military housing. The impact on military children is also tangible. In Anne Arundel County, to register for public school, you need to provide a recent utility or cable bill along with your mortgage statement to prove residency. If the military member cannot move into their home in time due to tenant holdover, the military's child is adversely affected.
Thank you, Bill Castelli, on behalf of the Maryland Realtors. And we are in support of the legislation. Many of our members are property managers that represent a lot of single-family rental properties. And we believe this bill is a very targeted bill. It's really for tenants who are out of that lease term. It's only for holding over actions. So we think this is a good bill and encourage support.
Mr. Chairman.
We'll take questions now, and then we'll hear from Matt Hall, who's virtual. We'll hear first from Delegate Grammer.
Thank you, Mr. Chair. So this bill's in the same posture as last year, is that correct?
That is correct.
Okay, and this is only one property because it's a primary residence.
That is correct.
And do you know what happened in the Senate?
This past week on the most
Last year with the bill? What was the discussion?
I don't know why it wasn't not passed out, whether other than timing, because I think it got over to the Senate very late last year.
And it was unanimous in the House, right?
That's correct.
All right, thank you so much.
Thank you, Chair, and thank you, Delegate, for bringing this bill. I see a letter with an amendment. Did you have a chance to take a look at that amendment? By any chance? I see Matt Hill has talked about allowing the landlords to supplement the central role of the sheriff in a nail and mail. Talk about maybe changing some of that language.
Yeah, I think he wanted it to remain with the sheriff's department, and we have not had a conversation as of yet. But I think when he reaches out to the sheriff's department, he'll understand why we put it in the bill to take the pressure off of all of the local sheriffs.
Yeah, that makes sense. I know we're at some of the highest rates of evictions in the state of Maryland. Was there any opposition to this bill last year in its posture?
No, matter of fact, I'm glad you brought that up because I failed to mention it, but we did get a letter of support again this year from the Veterans Caucus and the Maryland Military Coalition, and there was no opposition last year.
All right. Thank you.
Seeing no questions, no further questions for this panel, we thank you very much. We'll take Matt Hall, who is virtual, Matt Hill, who is virtual and now has 2 minutes. He's favorable with amendments.
Thank you, Mr. Chair, members of the committee. My name is Matt Hill. I'm an attorney at the Public Justice Center. We are favorable with amendments, certainly sympathize with some of the experience that's been testified to today, and don't have a concern with having the hearing within 45 days of filing. Our one concern is with, again, supplanting the role of the sheriff in the nail and mail process for these kinds of cases. So this is not, these cases, tenant holding over evictions, are not personal service. They are mailed by first-class mail and posting on the door to the unit by the sheriff. And that's a central role for the sheriff. And so I worry that if you're going to start allowing private process servers, that ultimately it's a slippery slope to then allowing private process servers further into the eviction process, which again, the sheriff is a neutral third party, whereas the private process server is paid for by the landlord. And so we'd argue that there's been no testimony really that there's a problem with the sheriff's performing this function. I understand the sponsor talking about a call with the Anne Arundel County Sheriff, but there's been no testimony in terms of the sheriffs are unable to do this important part of their job. And so we urge the committee to strike those lines that would allow private process server. Thank you.
Questions now. Delegate Simmons?
Thank you, Mr. Chair, and thank you for being here. Can you tell me what is the process of them putting a notice on a tenant's door? What does that look like, and what information is reflected on that form?
Sure. It's a copy of the complaint, which has the summons at the bottom. So it's what the landlord filed with the court. The sheriff then takes that and has the complaint with all the information that the landlord's given to the court and the summons, and the sheriff should post it to the door of the unit, and then also mail it by first-class mail to the defendant.
Yeah, what's on the form, I'm asking?
Oh, I'm sorry. It's the so it's the landlord says, I gave you notice. You haven't vacated the property at the end of the term of the notice. I want the property back, and here's the date and the time of the court hearing. That's the only notice of the date and time of court hearing, which is really, that's the critical part, that's then again posted and mailed to the property.
Sure. Does it have the tenant's personal information on it, or the amount owed, or anything reflecting the case?
Yes, so it has the tenant's name, their address. Again, when allegedly the lease ended, oftentimes will include the amount of rent, because landlords can seek damages in these cases as well. And so yes, there is a good, and sometimes phone numbers, I think. I'd have to go back and look at this exact complaint. It depends on the eviction type of case.
Sure, thank you. Yeah, thank you. Just FYI to you, Anne Arundel County Sheriff's Department is currently seeking to do away with that process. So, just so you're aware of it, they're currently requesting to do away with it. Thank you. No further questions.
Yes, Delegate Chisholm. Well, first of all, let me.
Okay, so we had him on a panel.
Yes, but I just thought of one. I'm sorry. I just thought of a question. I've thought of a question. Sorry about that.
Usually don't do this.
I'm sorry. I apologize.
Thank you, Mr. Chair.
Anyway, Delegate Chisholm, I really sympathize with your witness and with everything that she went through. But that's one terrible story, and so I'm just wondering how many people are affected by this issue. Are we talking 1,000 Marylanders, 500? About how many?
It was more, I can't give you an exact number. I will tell you that I was actually surprised by how many people it affected, because of, especially considering Fort Meade, because of BRAC and the realignment. I'm hoping it doesn't happen as often as we've seen in the last few years. I think that COVID really created a bigger problem. So I think if you were to ask me to give you a solid number, we're probably talking maybe 25 to 50 per year.
Great. Thank you, Mr. Chair, and thank you for your indulgence, and thank you, Delegate.
Thank you, Mr. Chair, and thank you, Delegate Chisholm, for bringing this bill. I mean, I'm a landlord, and I know how difficult it is when you go through the eviction process. I can't imagine what it's like for a military family who's transitioning often with family. So I appreciate the bill. I do have a question. The gentleman who is virtual, he said that his concern is with private process servers. Now, if our this process, we have these individuals who are, I'm assuming, a third party, who are trained, who, understand the process. I'm just confused as to what your concerns are with using the private process servers.
Sure. So in our experience, sometimes, again, because private process servers are paid for by the plaintiff to complete service, we have seen in the past some examples of private process servers claiming that they made service when our clients are very adamant that they did not receive service. The process server has an inherent conflict of interest here, right? The sooner he can say, I completed service, the sooner he is done with the job and can move on to take other jobs and make additional money. And the sooner he completes service, the more likely it is that the plaintiff, in this case the landlord, is going to want to hire him again to complete service on other cases. And so because of that inherent conflict of interest, we much prefer the sheriff, who does not have a conflict of interest in these cases, to complete service, especially when there is a high volume. I don't have the number of tenant holding over complaints filed each year, but I want to say it's at least 5,000. I'm pretty sure in FY25, I want to say at least 5,000 tenant holding over complaints filed in the state of Maryland.
So what makes the sheriff's process more reliable? I mean, are you saying that these private process servers are lying? I mean, are you saying that they're not really completing the job?
Yes, absolutely. And there are documented cases in the news media of private process servers who say that they have completed service when they have not, because again, they have this inherent conflict of interest. And this is not to impugn all private process servers, but there are several well-known examples of this. And so we do not think that that process should be opened into this very simple nail and mail service within the tenant holding over cases.
Thank you.
Chairman, thank you, Delegate. Thank you, panelists, for coming in to testify. I wanted to ask the question, does a private process server have to give a description of the location or the person that they served?
They do have to provide information as to who they served, yes, absolutely, and the address that it was served at, yes.
Thank you very much.
Can I add one thing for the good of the order to clarify that the process server can only be employed once the sheriff has not fulfilled his legal duty to serve within 10 days. So a process server cannot be employed until the sheriff's department has not fulfilled its statutory duty. So a sheriff would suffice all the way through as long as they did it in their legal timeline. Thank you, Mr. Chair.
All right, thank you all very much. That concludes the testimony on House Bill 229. We're going to move now to, I think, to two administration bills, if you're ready to go. One is, why don't we do House Bill 189 first, if we can? House Bill 189. I think it is just the two people from the administration, maybe? Yes, that's right. So go ahead.
Well, thank you, Mr. Chairman. For the record, Chrissy Nizer, Motor Vehicle Administrator. With me, I have Phil Dacey, our Director of Policy and Innovation, who's here to answer any questions. Here to testify in support of House Bill 189, which requires the MVA to disqualify a commercial instructional permit or commercial driver's license for operating or attempting to operate a non-commercial motor vehicle with a blood alcohol concentration of 0.08 or greater. The driver will be disqualified from driving a commercial motor vehicle for 1 year for the first offense, and the second offense is a lifetime. MDOT supports House Bill 189 as it'll bring Maryland in compliance with the Federal Motor Carrier Safety Administration regulations in this area, which require driver disqualification. In a recent FMCSA annual performance review, it contained a finding that we did not have the proper authority in this area. Federal regulation requires that disqualification actions be taken upon conviction, and FMCSA considers an admin per se violation to be a conviction. Pursuant to the state law, section 16812 of the transportation article, the MVA already takes action to disqualify once the individual is convicted or given a PBJ. So this would just allow us to take that action at the admin per se step. Again, it's a unique construct of Maryland law, as you know, in terms of admin per se, and that helps align us with the other jurisdictions. And so for some offenders, this will mean that they will serve a potential admin per se suspension concurrently with this qualification status rather than having to endure a suspension from the admin per se and then become disqualified later. So it actually allows those two to be done in concert with each other. For these reasons, the MVA respectfully requests a favorable report on House Bill 189, and we'd be happy to answer any questions from the committee.
Just for questions.
Here to help. All right, I have a question. So in lines 28 and 29 of what is existing statute, the law as it stands says that you can suspend the license for a year for if the individual drives or attempts to drive a commercial motor vehicle and they blow more than 0.04. So why do you need the additional language for .08?
So it's a difference about the admin per se step in the process that we have. So this would allow us to take the action at the admin per se step versus the conviction now.
And I guess the .04 is in a commercial, I'm sorry, the .04 is in a commercial motor vehicle, and then .08 would be any vehicle. So,
Oh, I'm sorry. So it would be
yes, we already,
any motor vehicle
That's
over
right.
.08, but just a commercial vehicle .0. Okay, got it. All right. So it doesn't require a conviction?
So the federal government considers our admins per se a conviction.
Just going and taking the test, DR-15, and
Yes,
they-
Mr. Chairman.
just that.
yeah, because you have a right to a hearing there, and they consider that right to a hearing a conviction, you know, according to their definition of conviction, which is a pretty loose definition,
Broad
but it is their
definition.
definition.
All right. Questions from the committee? Delegate Sample Hughes.
Thank you, Mr. Chair, and thank you for this piece of legislation. I just got a question as it relates to the process. So if I am driving a personal vehicle and I am driving drunk and I have commercial driver's license, what is that process then with your agency? Do the individual go through a hearing and you send out paperwork, and if they don't respond within a certain amount of time, what happens then?
That's right. I mean, the process really is the same, whether you're a commercial driver's license holder or non-commercial driver's license holder. The difference is the sanctions, right? Because for commercial driver's license holders, we have the additional disqualification action that the federal government requires us to take. So from a process standpoint, from a hearing standpoint, your ability to request that hearing at the admin per se level, which is in front of Office of Administrative Hearing, and then the court process. Process looks exactly the same regardless of your status as a commercial or non-commercial license holder. The difference is that disqualification action that we're required to take by the federal government. But Phil can walk through the entire process if you'd like it in more detail.
Did you want more detail on that?
Well, it comes from my inquiries because I had a constituent, it's been some time ago, but they were reaching out about some of the information on the process. I think they missed the date of when something was supposed to return back to your agency, and you were indicating, not you per se, but your agency was saying they missed this deadline, so the commercial driver's license is gone for like 6 months. And I was just curious to understand fully how this whole process works, and is that just a standard, or does the administrative judge say they have the authority to make whatever amount of time that they won't have their commercial driver's license, whether it's 6 months or a year? Does any of that make sense?
It does.
Yeah, so
Okay.
if they miss the deadline for requesting a hearing, yeah, we do go ahead and impose sanctions, like whether that's an admin per se hearing that they missed, or the conviction hearing that they missed. You'd have a right to a hearing at both. Yeah, we had sanctions at both. The administrative per se judge can adjust those points or penalties, but not against the statute here. So here, federal law really dictates what we can do with commercial drivers. We don't have really any latitude. We have to.
You don't have any leniency or anything like that gray area. It's just, this is what it is.
Because it's intended to be consistent all across the country. If somebody has a violation in Maryland or Pennsylvania or any other state, we all take the same sanctioning action against their license, and then we share that with all the other jurisdictions. So if that driver moved from Maryland to Pennsylvania, or vice versa, they would know what that was on their driving record.
Okay. All right. Thank you. Thank you, Mr. Chair.
And I don't know under what scenario this might happen, but I am curious. So there's an admin per se hearing. Driver is determined to be under the influence. There is then a appeal of some type, and it is determined that the driver was driving lawfully. Under what circumstance, I don't know. But it could happen, right? What happens then, particularly with their license, the commercial license?
Well, once a driver is pulled over in a personal vehicle, you're talking about under this bill?
Under this bill.
Yeah, so you'd be driving a personal vehicle or non-commercial vehicle, you blow up more than a .08, you're gonna have the right to go to a hearing. You can go to the hearing, you can make your case to the administrative law judge. That could be, they didn't have grounds for the stop, or it was an illegal stop, or, I ate a bagel or whatever it is, and the administrative law judge can say, all right, I agree with you, I'm not going to take sanctions, and at that point, there'd be nothing, if the administrative law judge told us not to take sanctions against the person. But if the administrative law judge upholds the sanctions for the 0.08 or greater, we would get a notice. We would then propose that we would disqualify you for up to 1 year if it's your first time, or lifetime if it's more than your first time.
And if they would appeal that to?
If they appeal the
decision.
Yeah, I mean, you can always appeal to.
And if they were successful, you would have already reported it.
If they were successful, yeah, if they were successful in challenging the administrative law judge's decision.
Then what happens?
Well, I guess we'd have to, we would follow any court order.
Impose what the court said at that point.
Yeah.
So we'd have to then communicate back with the feds?
Yeah, I mean, ultimately, if the person's not guilty, or, if they get their conviction overturned or their sanction overturned, then we have to, then the feds don't consider that a conviction. So we wouldn't take the required actions against disqualification unless there's a conviction in the federal definition that's been upheld. So if it's been overturned, then yeah, we wouldn't have any federal sanctions that would be required.
But there would be a period of time that they wouldn't be able to drive. They would.
Yeah, potentially. Well, okay. It's pending. Or...
Valentine.
Thank you, Mr. Chair, and thank you, panel. I do have a question with regards, and this could be how you're handling these now or with this new legislation. How are you handling refusals? I don't see anything about refusals listed in here. So if you have an individual who decides to decline the breath test,
right.
How are those handled now, or would they be handled under this legislation?
So there wouldn't be any changes to refusals under this legislation. It would be handled the same way it's handled now. And we're allowed to take already under existing statutory authority action for CDL drivers.
If they're operating a commercial motor vehicle now,
yes,
and they refuse,
that's right.
There's administrative actions now. So they would just follow
authority.
with this.
Yes.
Thank you.
I did not. All right. Seeing no further questions, we thank you both very much, and that concludes the testimony on House Bill 189. We'll go now to House Bill 70, and I think it's the same group, so go right ahead.
Thank you, Mr. Chairman. Again, Chrissy Nizer, Motor Vehicle Administrator, and here in support of House Bill 70. Each year, we know that you have undertaken legislation to help address roadway fatalities and vehicle crashes. I always like to start off by saying we use the word crash, not accident, because regrettably, we know that the causes really are excessive speed, impairment, as we've just discussed, distracted driving, not wearing that seatbelt, and aggressive driving. Those are all deliberate actions that somebody takes when they get in the car, whether they consumed before they got in, whether they drove too fast or didn't buckle up. And so we know that on average, there are 190 fatalities in Maryland roadways due to an alcohol-impaired driver. House Bill 70 would revoke the driver's license from an individual convicted or granted probation before judgment for driving under the influence of alcohol or drugs for a period of 5 years if the crash contributes to the death or life-threatening injury of another person. Literature reports that individuals that have been sober for 2 years have a relapse rate of 40%, but that relapse rate drops to 7% for individuals that have been sober for 5 years. Under current law, there is absolutely no distinction between different reasons for revoking an individual's driver's license. So for example, over a period of years, you receive points on your driving record. Those points add up to 12 points, which is the revocation level. You would be treated exactly the same way as an individual whose license is revoked because they killed somebody in a crash or fled from the scene. There is no distinction in terms of how that's handled. On average, we know there are over 27,000 hit-and-run crashes each year in Maryland. Vast majority of those only involve property damage, thankfully, but there were 255 crashes that involved a hit-and-run driver, which contributed to 258 fatalities over the last 5 years. After this period, the reinstatement process for a driver's license would remain the same. So the process they go through would be the same, but it would establish a period through which you'd have to wait in order to get that license reinstated. For those reasons, we'd respectfully request your favorable consideration.
Just for questions.
Thank you, Chair. Sorry, I misunderstood some of the numbers. There was some noise in the back. How many crashes per year in the state of Maryland?
So yeah, there's a few different data points. So in terms of fatalities, on average, where alcohol is a factor,
I saw
that's
190.
190. That's right.
How many were the hit and run?
The hit and run, it's about 27,000, but many of those are just property crashes. There were 255 crashes involved a hit and run driver that contributed to 258 fatalities. So
255 crashes that contributed to 258 fatalities.
that's right. And that's over the last 5 years, I should say. The other annuals,
Okay.
or numbers were annual.
Ironically, I have a bill to put this in law for boats as well. That's going to be heard in a few weeks. So if you could find out how many crashes, well, I'm sorry, my question would be how many fatalities on roadways per year?
So the number varies per year. We did go down slightly last year in terms of
Was it
fatalities.
1,500 or something?
I'm sorry.
Was it 1,500?
No. What it was?
If you could just let us.
I'll get it to you.
Okay.
I don't have it tip of my, I think it was 571, but don't quote.
Okay, thank you. Maybe like a 5-year.
Sure, we'll get back to you,
Okay.
no problem. We'll get it to the whole committee if you'd like it.
Yep.
Any other questions? I guess I have a question about the interlock. So the bill would say that if you fail to remain at the scene of an accident that results in death or bodily injury, that you would then be subject to the interlock, and that's a shall? Lines 11 and 12 on page 5. So while you're
think this
reading, I guess
provision-
my question is, and perhaps I'm quibbling a little bit here, but we include the requirement to get the interlock when there has been something proven generally where there has been a connection to alcohol. And it's possible that that you could fail to remain at the scene of an accident that results in death and bodily injury and not have anything to do with alcohol.
Yeah, I think what this section is referencing is for those individuals who have been convicted of an alcohol offense already. The 205, or 16205B under 4.
So it would be that they picked up a DUI and they were convicted of the DUI and they were also convicted of leaving the scene?
Yeah, they're already revoked.
For an accumulation of points under, yes, that's right.
So it would be both? Okay.
So yes, I mean, as part of the reinstatement process, we look at whether alcohol was involved or not today. I would say honestly, in most cases where there was a fatal crash, 97% of them involve some sort of impairment, whether it was alcohol or drugs. It's a very small percentage.
I maybe spent a little too much time thinking about this bill, but so I get it, and I understand that piece of it. I just kind of wonder, when it goes into that section where it says shall, it doesn't leave any room for that. But maybe we don't care because it was an accident that involved the death or bodily injury of another person. So I get it. I just,
Yeah,
it's
I mean,
kind
we'll
of,
confirm the references,
it's a little bit outside the DUI universe, I guess. But that's all. All right. Are there any other questions? Delegate Tomlinson.
Thank you, Mr. Chair. I know that the bill's titled drunk and drug impaired. Has there been any developments to your knowledge as far as being able to identify whether somebody's impaired, as a result of, whatever, fill in the blank drug? Because I know that that's something that gets brought up a good bit. Obviously, with how the laws have changed in the last couple of years as it relates to cannabis. Has there been, to your knowledge, has there been any advances floating around the universe as far as being able to actually accurately detect that on the scene?
There have certainly been discussions throughout the jurisdictions. There is no consensus that is yet developed in terms of like a 0.08 for drug consumptions. As you know, and we've talked about before, generally what happens if you're tested and you wind up being 0.08 or higher, even if There's some drugs as well involved in the impairment. Most oftentimes it stops there unless there's a fatality or some other more complex situation. And so we don't truly know, frankly, how many individuals are out there driving impaired from drugs in addition to alcohol, except generally for those that involve fatalities. We have done a lot of efforts in providing what's called green labs for our law enforcement officers. What that does, it provides a safe environment for individuals, generally medical marijuana patients, to consume in a safe environment and engage with law enforcement in terms of what that looks like as they become more impacted by the cannabis. It provides a way for law enforcement to understand when they encounter somebody at roadside what they can potentially expect and how they can engage with that individual when they have consumed. But that's more of an educational outreach type of effort that we do in training for law enforcement.
Gotcha. All right, thanks.
There's a number from 2024.
Seeing none, thank you very much. That concludes testimony on House Bill 70, and we'll have the last bill of the day, House Bill 171. Delegate Valentine, who's making his way up to the front. There are several people who are testifying. Well, let's see how this is going to work. We're going to do, well, since I think Mr. Jocelyn, or Mr. Pennock's here, right? You're not virtual, at least I can't tell. So why don't we do this? We're going to take your first panel, and then Mr. Pennock, Mr. Jocelyn is virtual, we'll do you next. And then Karen, hi, okay, then third. Okay, that's fine. So Delegate Valentine, go ahead. 3 minutes for you, 2 minutes for everybody else.
Thank you, Mr. Chair, and good afternoon. Chair Clippinger, Vice Chair Bartlett, and members of the House Judiciary Committee. For the record, Delegate William Valentine, District 2A, representing both Washington and Frederick counties. I'm before you today to present House Bill 171, Public Safety Handgun Permits Expiration and Renewal Periods for Retired Law Enforcement Officers. This bill seeks to extend handgun permit renewal periods for qualified retired law enforcement in good standing while reducing a portion of the administrative workload on our Maryland State Policing Licensing Division. Current law states a handgun permit may be issued to those who qualify for the carry, wear, and transport of a handgun. The initial permit lasts to the last day of a holder's birth month, following 2 years after the permit is issued, and may be renewed every 3 years. Maryland renewal permits are somewhat more restrictive than other states, specifically states surrounding the state of Maryland. For example, Delaware has an initial permitting period of 3 years followed by a 5-year renewal. Pennsylvania, 5-year renewal. Virginia, 5-year renewal. West Virginia, 5-year renewal. I also did some research. Michigan has a 4-year initial as well as a 5-year renewal, and the state of Massachusetts that has a 6-year renewal. What this bill does is a step forward in bringing Maryland into line with our surrounding states by creating a 5-year term for an expiration of a carry permit, which this legislation limits to a retired law enforcement officer who retired in good standing from service of a law enforcement agency of this state, county, or municipal corporation. The Senate crossfile in this legislation, Senate Bill 180, was voted favorable out of committee just recently with no amendments and is currently awaiting its third reading in the Senate. This bill is specifically about trained, experienced individuals who have served judiciously in our communities for many, many years, oftentimes decades, and have displayed a strong level of accountability to their communities, and I would respectfully request a favorable report. Thank you.
Mr. Chairman, distinguished committee members, my name is Donald McCord, and I'm a retired lieutenant from the Maryland State Police. I am testifying today on behalf of the Maryland State Police Alumni Association in support of House Bill 171, extending the renewal time for a Maryland handgun permit from 3 years to 5 years for retired law enforcement officers. The Maryland State Police alone are charged by law with conducting handgun permit investigations. With more than 85,000 applications processed in 2023, this presents a daunting task. a trooper's time and man hours, salaries, equipment wear and tear, fuel costs, are just some of the expenses to be considered. Given the volume of applications processed, many of these investigations are conducted on an overtime basis to avoid taking time away from more pressing and time-sensitive criminal investigations. To put an even greater demand on overburden, this puts an even greater demand on overburdened police resources and budgets to investigate known, highly trained, law-abiding individuals who have served this state and their community with honor and distinction. In addition to the points mentioned above, this bill, if passed, would bring Maryland in line with our neighboring states of Delaware, Pennsylvania, Virginia, and West Virginia, each with 5-year renewals. Number two, it would provide significant savings to the state of Maryland and allow law enforcement to reallocate precious resources where they are most needed. As an active duty or retired law enforcement officer, we are held to a higher standard by the community at large, with much greater expectations of conduct and character, especially in times of trouble. Those of us who have chosen to pursue the path of a law enforcement officer embrace these expectations and live their lives accordingly. Given the years of dedicated service and sacrifice to the state of Maryland and our communities, we would appreciate your consideration in extending the renewal time for our handgun permits from 3 years to 5 years. Thank you.
Yeah. Good afternoon. My name is Brian Blueball. I'm a sergeant with the Maryland State Police and the president of the Maryland Troopers Association that represents active and retirees. I've been on the job for almost 29 years now. I've been a firearms instructor for 25 years with the department. With this particular bill, this is simply easing the burden of our department, of our licensing staff, on processing these types of applications to renew a permit for retired law enforcement. And the key is in good standing. And the fact that these folks are still checked annually, just like anyone with a permit. If someone was to get in trouble and arrested for some crime, they would be flagged in the system, and it would automatically tell that their permit could not be extended. The fact that we're extending it just from 3 years to 5 years is simply to make the process easier without an additional cost to any member, and to simply ease the burden of our licensing folks when that's one less group of people that they need to worry about in renewals. To fall in line with other states that are around us that have a similar bill and or a similar law, and it has worked fine. Based on these issues, we ask for a favorable report.
Yes, sir. Christopher Dews here with Cornerstone Government Affairs, representing the Maryland Troopers Association. Good to see the members of the committee. This is my first time being back, and with a pretty great client. So all the talking points have basically been covered. The only thing I just wanted to highlight is that we know that there's a $170,000 fiscal note. We are working with the fiscal basically drafters to try to pinpoint where that number is and why the number is what it is, and we're trying to get that down now. It seems to be a very slight technical fix, and we may be working with some groups that can make that happen. Other than that, it's a pretty straightforward piece of legislation. Cornerstone has been, of course, in contact with the Senate on this, and the kind of tacit agreement that we've all come to agreement with on this specific issue is that we want to start here with retired law enforcement officers. We think it's a pretty safe group to kind of push this extension to, and then we just kind of build out from there if necessary in the future. But as it is, retired law enforcement officers in good standing, that's what the bill says. We just want to extend and alleviate the burden on them just a little bit. So with that being said, I urge a favorable report, and I thank you for your time.
Delegate Coles, request.
Mr. Chair, question or two, if that's okay. Thank you. So the first question is the only reason you're looking to get the extension is because it's not enough time to be able to, I'm sorry, not the extension, to be able to look over the renewal applications? I guess I'm saying you have 3 years, you need 5 years. I just need further clarification on the length of time, just.
No, so
If you could use the microphone, I'm sorry.
So the 5-year extension, the backgrounds will, it's not that they're going to be delayed. The backgrounds will still have to be done, but as of right now, with a 3-year, that's an extra group being retired law enforcement that has to have that background done where they can worry about other groups and not focus on more, being background checked and processed through the system within 3 years. If they can just push it back to 5 years, as well as if there's any additional, costs or anything that law enforcement would pay to have that permit renewed, it would give them to 5 years. And sometimes the 3 years comes up very quickly, and, giving them 5 years is just gives them a little extra time to, I guess, not realize that these things, are coming up for renewal so quickly. That seems to be one of the biggest complaints from retirees, is that, I just feel like I just got this thing, I just got it renewed, and all of a sudden, man, here we are, 3 years already. 5 years, it would just, make it a little easier and fall in line with the other states. Some of these folks even live out in other states and have a permit in both. But they're like, I can have a permit in another state for 5 years, then I come back to my home state and I have to do it in 3.
Okay, and just another quick question, Mr. Chair. What are is law enforcement the only group that, I'm sorry, everyone else would be 3 years? We've rephrased that. Everyone else is currently 3 years. So
yes,
across the state is 3 years, but you want the exception for law enforcement to be 5 years, and everyone else would stay 3 years.
That's as this current bill, yes.
Why should law enforcement have any other retired law enforcement? And I'm just asking, not that I love, everyone here knows I love my law enforcement in Prince George's. I'm just asking, generally speaking, why is it more important for you to have it versus others?
Well, our main thing is, number one, that we are representing active and retired law enforcement. And that is our primary, objective, is to look out for those who have asked for this type of bill change. And, not that we have objections of, or don't think that anyone else would be qualified or good enough to have such a bill, but with law enforcement who retire in good standing and have carried the weapon, have been trained for an entire career and so forth, we think that this would be the easiest step to get this passed. And then, if there's more discussion down the road for others to try to emulate that, we have no opposition to it.
Okay. Yes, sir.
If I may add something to that.
If you could use Delegate Valentine's microphone.
Thank you, sir.
Thank you.
When you, I guess, walk across the stage and graduate, you've gone to the other side, so to speak. You take the uniform off, but you don't put the job away. We still live in our communities. We're the ones that have the eyes in the neighborhood for the strange vehicles that don't belong there, or the activity that may not be quite right. Many times our folks go on and they provide free security to the carnivals and things like that in the communities. They do bank runs for their their local churches and school bazaars and things like that.
They're not pulling out the guns at the school bazaars, are they?
Oh, God forbid you ever have to pull it out.
Okay.
But they're also going to be the first one when the law enforcement officers stop on the side of the road and they're all by themselves and they look like they might be in trouble. They're going to be the first one to stop and put themselves back into harm's way to help that officer. So it's kind of a little bit of a recognition for the years, not only the years of dedicated service that they've given to the state and our communities, but it's also to acknowledge what they do, what they continue to do, but they don't get paid for.
Okay, I don't know if that was really helpful because I want to make sure we're not pulling out guns when we don't need to in the community.
No.
But I will say I completely understand. I have a retired police officer, lives in my neighborhood. You don't ever need them, but I do understand the importance of being able to have your licenses, properly, being able to have them properly, but
Nobody ever wants to
move
have
with
to
caution in the community is all I'm saying. Okay.
Nobody ever wants to have to take a
That's nothing to
gun
do with
out.
this bill, but I
Ever.
just wanted to know the emphasis for you guys versus anyone else. So thank you, Mr. Chair.
Thank you.
Delegate Kaufman.
Thank you, Mr. Chair. I remembered in time this time. My question is for Delegate Valentine. The Marylanders to Prevent Gun Violence is opposed to your legislation. And they say that basically because people who fail to uphold standards should be subjected, there should be consequences for them in their letter. I'm paraphrasing. But aren't there other ways, you probably know this as a former police officer, to assess consequences and potentially, if necessary, take a gun away from a retired officer if they conduct themselves with their gun inappropriately or illegally?
I did, thank you, Delegate, for the question. I did read their testimony, their written testimony, and I think when the state police and the gun center was here for a briefing in this committee a few weeks ago, I specifically wanted to know those safeguards. I wanted to know that we would not be issuing permits, say this month, something transpire and there be a 5-year gap. So I believe the testimony of the troopers that day spoke of whether someone be arrested and fingerprinted, they would receive notification. Whether cases are adjudicated through the courts, they are notified. All of these safeguards and all of those different databases that interact so that they would know no different than if it's a 3-year time frame or a 5-year time frame.
Thank you, Delegate Valentine. Good bill.
Delegate Conway.
Thank you, Delegate and panel, for coming in. To the witness who's on the right-hand side of Delegate Valentine, you said when you see a strange vehicle that does not belong there, what does that mean exactly?
In your neighborhood.
In my neighborhood? In my neighborhood?
If you're in your neighborhood and you know what cars belong.
I don't.
What?
I honestly don't. Are you an officer or a retired officer?
I'm retiree.
Okay. I honestly can't.
In my
tell.
particular neighborhood, because I know all the neighbors around me, if I see somebody sitting in the car that is not a car from that neighborhood, it looks strange. It's out of place.
Do you know what a hoopty is?
A who?
A hoopty. How do you tell somebody struggling trying to have a low-valued vehicle, and let's say their engine blows up, they get another low-value vehicle? How do you tell which hoopty is which?
Well, sir, I'm talking about vehicles that might be sitting there for hours on end. Maybe somebody that's sitting in there, they're not part of the neighborhood.
I had someone in my community speaking about me sitting in the car for an hour, and they thought that I was scared and I was listening to a religious program. So if you see someone sitting in this strange vehicle, I mean, I was with you, Bill, but now if you're talking about being a citizen on patrol.
No, I'm talking about just notifying law enforcement that there might be something strange going on in the neighborhood and let them investigate. We're trained
That's, in my community, that's called profiling, I think.
No, sir.
No? Can you
No,
explain
sir.
to me what the difference is?
Profiling.
You profile the vehicle, right?
Sir?
You're profiling the vehicle?
No, sir.
So I still don't understand how you tell what vehicle is.
I'm trying to think of the best way to, I'm not talking about anybody of any particular race.
I didn't say race, you said a car.
Or.
You said a car. You can't identify what kind of car.
Or
I'm
young
gonna be
or
driving.
old.
I could be driving my grandmother's car, my uncle's car, my daddy's car, anybody's car.
I'm trying to think of the best example
Okay, well,
to give
while you
you.
doing that, let me ask you this. So when you renew your MVA license, do you have to take a eye test?
Yes, sir.
When you renew this handgun permit, do you have to take an eye test?
No, sir.
If you get revoked on your driver's license test and they say, oh, you have to wear your glasses, you have that restriction, will you have that restriction for your handgun permit?
I don't know of anything that requires you to.
Well, I understand that, but let me tell you what I did. I lifted up my new trifocals and you all look all the same. So I thank you very much.
Good to look the same. Thank you, Delegate.
Thank you, Mr. Chair, and thank the panel for coming out. Can you talk a little bit about weapon retention and the training that officers go through in their lifetime of training for weapons retention when it comes to that weapon or any weapon of that sort?
Well, obviously, and it's changed over the years, based on different technology that's out there as far as holsters, types of guns, and things like that. I'm sure that when Mr. McCord came through, they might have had an old flintlock muzzleloader. I'm not sure, but and today, with weapons we carry, it has 3 different retention devices on it to keep someone from able to just reach in and pull the trigger with their finger, be able to just grab it and rip it out of the holster. And there's different mechanisms you have to apply to get the weapon out of the holster. And then throughout the academy, you're taught different defense tactics to, if someone is trying to take your weapon out of its holster, what you can do to try to keep their, keep that retention locked in place so they couldn't take your own weapon from you. And then when you go to in-service training and things like that throughout the years, if new training comes out on a different method or a different holster, and we've changed guns and holsters over the years, but they will teach you how to use that holster or those retention methods to keep the gun safe and in its holster.
Sure, thank you. Can you just explain, for all intents and purposes, off-duty officer or retired officer in a lifetime of being a police officer, a law enforcement officer, the training that they experience when it comes to situational awareness, looking at an individual, being able to determine a threat, non-threat, daytime light, nighttime light, when it comes to your weapon?
Quite honestly, if somebody is retired or off duty, they are exactly that. They have no police powers at that time unless they see an actual crime occur that would put them back into a duty status if they're an active police officer, to go back into that duty status to assist during that crime. And as a retired person, you do not have any of those police powers. You may be, over your career, have taught, to, if you see somebody parked out in front of a bank wearing a ski mask, that may be somebody you want to keep an eye on a little closer, because they might be cold or they might have some other criminal intent. Not that you're going to act on it. You're definitely not to just pull your weapon and walk up to them and confront them or anything. And to do that even by yourself would be foolish and dangerous. You would want to call the actual police on duty, inform them of what you saw, and then at that point, it's that police department, those police officers who respond, that's their responsibility to handle that as they see fit, and you are not to get involved. If a police officer or an innocent civilian was being, assaulted, shot, stabbed, something like that, and you want to try to protect that person or yourself if it's in the same, area, that's different because that's a self-defense or defense of an innocent person. But at no time should you be taking the matters into your own hands and pointing weapons at anybody or anything just because in your perception you think they seemed out of place or whatever, because that's not how we do things.
Thank you.
Nice. You sure? Delegate Williams.
Yes, hi, Delegate Valentine. I missed the beginning part of your remarks, so I apologize. I think, what states did you state have currently a 5-year renewal period?
I wanted to emphasize the states that border Maryland. So Virginia, West Virginia, Pennsylvania, Delaware is an initial 3, renewals are 5.
Got it.
And then I added a few other states that I had my intern research that I just put in Michigan and Massachusetts just for some different states. And then there was additional that I did not submit in my original testimony that talked about, that I had researched, that were 29 states as of March of 24 that are constitutional carry states that do not require a permit at all.
Okay, thank you.
Thank you.
Delegate Grammer.
Thank you, Mr. Chair. Just wanted to clarify the gentleman's statements about continuing to be vigilant. So what you're saying is for retired law enforcement in their community, for example, in my community, we had issues with cars driving by, being a little too close to the kids when they got off the school bus. People walking by, looking in people's property. Those are the kind of situations of retired law enforcement in a voluntary capacity. Those are probably the folks that are continuing to be vigilant in their community. Is that generally what you're getting at?
Yeah, you want to keep your community safe. Your trained eyes. You're not taking enforcement action. You're calling your local barrack, your local sheriff's department, county police.
Just wanted to clarify. Thanks so much.
If I may, to that, just want to be very clear that the purpose of, and I know you know this, Delegate Graham, the purpose of this legislation is simply to expand the waiting period to match other states, the renewal period to match other states, and also to respond to Delegate Tolles' question. The reason why it was limited to just retired law enforcement officers, keyword in good standing, was as an agreement with conversations with leadership and community and things of that nature. So it was a very specific subset of individuals that we wanted to target so that we can at least start the conversation on what renewal expansions would look like. But thank you both for the questions.
The second bites of the apple, Delegate Conaway on the bill.
Thank you, Mr. Chairman. Thank you, panel. Thank you, Delegate. So, Mr. Dews,
yes, sir.
I see that you excluded some of my comments, so I don't know if it's appropriate. I guess the chairman will school me in a minute or two after 19 years. But what is the meaning of defense? What is the legal definition of defense of an innocent person?
The legal definition of defense of an innocent person.
Yeah, you just heard it in testimony.
I don't think I have the proper answer to that question, Delegate.
Okay, well,
I
I'll wait for you
apologize
to
for my
get it to me.
ignorance.
Thank you very much.
Yes, sir. Thank you.
I apologize. Started this, but welcome to Judiciary. This is fun. I just want to, I do have a follow-up, but I would be remiss if I did say that. I may be looking at a property because I want to purchase it, which is what I often do when I go walking. Doesn't mean I'm going to take something from it. And people have got killed for looking at properties or bird watching. So I would just say, just keep that in mind. Now to the bill. Ms. Delegate Valentine, would you be open to, I have several letters here that states that many individuals, not from my county, but Cecil County and other jurisdictions are asking for it to be all citizens. Would you be open? I'm not saying I agree to that per se, but I was just asking, just based off some testimony, committee testimony that came in, particularly from the Maryland, the State Director of the National African American Gun Association, other individuals in here asking for it to be open to all citizens. Would you be open to that amendment if that was presented? I'm not doing it. I was just asking, would you be open to that amendment?
If I may respond.
No, I asked Delegate Valentine. Thank you, though.
Absolutely.
Appreciate you.
Thank you, Delegate.
You're welcome.
And yes, once the bill is presented, it is no longer my bill and becomes a product of this committee. So I would certainly be open to any amendments that may be set forth.
It's very well spoken from the minority leader of the committee. So thank you. That's it. Thank you, Mr. Chair.
All right. This has been the first panel for this bill. We'll move on now. Thank you all very much to the second panel, one of whom is virtual. John Jocelyn is not there, but Mr. Panak, come on up. Mr. Panak, and in the past, I'm not making light of Mr. Jocelyn, but sometimes he jumps on right at the right time. So we'll keep an eye out for him. But Mr. Panak, please go ahead for 2 minutes.
Thank you, Mr. Chairman. My name is Mark Pennick. I'm the president of Maryland Shall Issue. I'm an attorney, and I practice in Maryland and District of Columbia and all over the country. So I agree with all the statements that the sponsor made in this panel, and I would caution the committee with a fact. And right now, as of July 1, 2024, there were 194,053 permit holders in Maryland. All those permit holders are coming due for renewals. And the state police is spending an enormous amount of resources to renew them. And there is no point to spending that money. Just the process for permit holders is very expensive because the state requires extensive training and a lot of money for everyone. But the Maryland State Police is bearing the brunt of that because what they have to do is do the background investigation after the initial permit after 2 years and the subsequent renewals after 3. And there's no state in the union except for 2 that actually requires that sort of a very limited renewal period. All of our neighbors in New York State, no less, includes 5 years. So I'm an instructor for this permit. I teach people how to do it, and most of the people who come through who are serious about getting the permit, and it takes being serious because it's expensive and time consuming, are devoted to learning the rules and abiding by them. The numbers are quite clear that permit holders are the most law-abiding people on the face of the planet. They don't commit crimes. Now, I yield to no one in my admiration for retired officers, but retired officers who qualify every year are entitled to carry under LEOSA. They don't need a Maryland permit at all. So they already have the privilege of carrying far more extensively than people with carry permits. But what we really need, if you want to save the state police a lot of money and the applicants a lot of money, is doing what other states have done, including New York, and do this for 5 years. I'm happy to open, and Delegate Conway, I know the answer to your question about innocence.
Thank you, Mr. Chairman. Thank you so very much. Would you mind answering my question, please?
My pleasure. It's Maryland recognizes, as do all states in the union, defense of others as a legitimate exercise of use of lethal force. And the criteria for doing that is that the other has to be, a reasonable man would have to perceive that other to be in imminent danger of death or severe bodily injury. That has to be a reasonable belief and sincerely held. So that's the test in Maryland, and that's the test in most of the country.
Okay, so we're talking the average prudent man?
Yes, the reasonable man,
So
the one that doesn't
reasonable man.
exist in nature.
Okay, so you see three people in a knockdown, drag-out fight. How do you know which one is the innocent one?
Well, you don't employ lethal force at all in that unless someone is about to die. Because you don't use lethal force where you cannot reasonably say that someone's in imminent danger of death or severe bodily injury.
You have three people there, each with machetes or knives or whatever. Somebody's in imminent.
Well, what I tell my students is call the police because you don't want to get in the middle of that.
Thank you very much.
All right, are there any further questions for Mr. Pennock? Seeing none, we thank you very much. And we're going to go to Karen Herron, who's here. She's speaking in opposition. Who are these people who came into my room? I don't know who these people are behind you. We'll have to figure that out in a moment. But that's fine. I'm sorry, say that again? Oh, from the Elijah Cummings Youth Program. We'll be with you in a moment. Let's hear from Ms. Herron, and then we'll be with you in a moment. I would strongly encourage you to select 3 or 4 of your strongest speakers to be available here in a moment. Ms. Herron, go ahead.
Hello, I'm Karen Herron with Marylanders to Prevent Gun Violence. Good afternoon, Chair Clippinger, Vice Chair Bartlett, and distinguished members of Judiciary. Here in opposition to HB 171 that would chip away at some of the hard-fought improvements that Maryland legislators have recently made to our handgun qualifications licensing system by giving retired law enforcement officers extended time in between renewal periods. I first want to acknowledge the very important role of law enforcement in our society generally and specifically with regards to public safety. They play an integral role in the public safety ecosystem. That said, retired law enforcement officers are not inherently worthy of special protections that other people that also do amazing work every single day do not get. People who are not regularly singled out and given special protections and allowances in our laws. Pursuant to Maryland Public Safety Codes, Section 5-304 and 306, retired law enforcement officers already get special allowances when it comes to the handgun qualifications licensing system. They are not required to pay the fees that were designed to cover the cost of processing the application, and they are not required to complete the certified training course for the license or the renewal. The more frequent checks designed by the shorter timelines between renewals were designed to help filter folks who had become prohibited since their last application. Studies indicate that law enforcement officers, including retired officers, have higher than average rates of domestic violence violations. Additionally, data on other behaviors related to firearm misuse is inconclusive, making broad exemptions a risky proposition. Public safety laws should apply equally to all individuals, ensuring that firearm access is based on rigorous standards and not professional history. A badge, past or present, should not be a blanket exemption from the very safeguards that we've designed to protect Maryland families. We urge an unfavorable report on HB 171.
Questions? All right. Seeing none, thank you very much. That concludes the testimony on House Bill 171. It concludes our bill hearings for today as well. However, since there are people here from the Elijah Cummings Youth Program now in the committee room, I would ask for 4 of your finest speakers to please take the table so that we can ask you some questions. 1, 2, 3, 4. All right. You'd start from my right, your left, and just introduce yourselves to the committee, your name, where you go to school, where you're from, and we'll go right across, please.
My name is Dylan Rooks. I attend Baltimore City College High School, and I go to Baltimore City. Well, I'm from Baltimore City. My apologies.
Hi, my name is Samuel Hanna. I go to Beth DePhil DeHaan Community School, and I live in Baltimore County.
My name is Moss Paleyeth. I go to Pikesville High, and I live in Baltimore County.
Good afternoon. I'm Julie Strayton. I go to the Bryn Mawr School for Girls, and I live in Baltimore City.
All right. Do members of the committee have any questions for this panel? The vice chair.
So, how are you all doing?
I'm great. How are you?
Good. That was my question. No, I have another one. So tell me about what you all are doing here today. Perhaps anyone could answer that question. What are you witnessing? What have you seen?
So we have came to Annapolis to just take note and to realize what the delegate, the House, and just what the government is technically. Because I know some of us, we haven't really witnessed anything like this. So with the Elijah Cummings Youth Program, it gives us more spotlight and it gives us more, I want to say, freedom to, witness things like such as this, because a lot of people really don't get that privilege. And I just want to thank the Elijah Cummings Youth Program for giving us this opportunity to witness everything that's happening today.
Well, all right. Good answer. Thank you.
Delegate Tomlinson.
I'm not familiar with this program. Can one of you tell me what the program is?
I got you. So ECYP was created by Elijah Cummings. He created it with a group of people with the intention of bridging the Black and Jewish communities in Baltimore. So it's just leadership and community building and intersectionality as a whole. And then we take a trip usually to Israel, but this summer we're going to Eastern Europe to focus on Holocaust history. And yeah, did I miss anything?
No,
You're good.
Oh, shucks.
Yeah.
Yep.
Yeah.
I am really, really happy to see you all of you.
Thank you.
Elijah Cummings was a friend. And he had this saying that many of you, I'm sure, have heard, that our children are the messengers we send to a future that we will never see. He really meant that, and you are the fruits of his vision. So thank you for being here.
Of course. Thank you for having us.
Thank you.
Delegate Kaufman.
I want to know, do my friends at the Baltimore Jewish Council, Howard, Sarah, and Abby, take good care of you guys?
Yeah.
Absolutely.
I'm good, because if they didn't, you could come let me know.
We want to thank you all very much for being with us today. The previous chief of staff for the committee, Dylan Goldberg, was someone very involved and very active in this program. And so I have let him know that we have you at the table and are grilling you appropriately, and he's very happy, very, very happy to hear that. Thank you all for joining us in Annapolis today. This has been the House Judiciary Committee, and we stand adjourned. Thank you all very much.
Thank you.